Okay, so this is our third meeting, and let's see, we've got Emma is not new to us, and my bar is in the way, so I can't see who's is that Evan? Maybe.
Yeah, I'm in.
Sean is new to us. So Sean just joined today, and he is going to be on the prosecution team as a lawyer. And Brooke is also going to be on the prosecution side. Emma is going to be on the defense. Evan's going to be on the defense. And Saya is going to be on the defense as well. So essentially what we're going to do, because we have so many lawyers, is have everybody work together as a team and figure out how best to present your information at competition. And then when we get closer to competition, you guys can make the decision of 4 of you can actually be in the competition, and then the rest of you will be alternates. So, but we'll talk more about that later. But we have a full team now, and Dean is here to talk to us about the depositions. So what I'm going to do is make notes on all of the depositions, and then I'll be able to send them to you, so you guys don't have to take notes as you guys are working. I'll do that. And then you just tell me what to type, and then that way I can be your secretary. So I'm going to mute myself and let Dean do all the talking.
All right, thanks. So we've just so for the new folks, there are a couple of videos previously. The first one, we talked about what mock trial is, what happens in a mock trial, opening statements, direct examinations, cross-examinations, and closing arguments, and kind of what to expect from those things and what you're going to try to do with those things if you're an attorney. And then the second session, we tackled rules and hearsay. You know, I feel like we've had 3 sessions, but because I know we spent a lot of time on hearsay, which might have been almost a full session. But
I think maybe you're right. I think the first one we just kind of like, maybe we have had 3.
Yeah, I think so. I think the first one was a broad overview. The second one was just rules. And the third one was specifically on hearsay, and
yeah,
which is a rule, but it has a lot of facets to it. So now I think best thing to do, and if you haven't read the packet, please read the packet. You have to read from front to back, no matter what role you want to be in this thing. It's a pretty interesting, cool little case, I think. And I think you'll like it, and it'll get you excited about about participating in this, because I think it'll be fun. So read the packet, but right now we're going to get into into the depositions and talk about each specific fact and whether that fact from the testimony is good for the prosecution or good for the defense. And so we're diving into the trees, but don't forget the forest. All right. So we're gonna dive in to get into some specifics here, but we're not gonna forget what the entire case is about, what the theme is about. So what a deposition is, it's testimony under oath, just as if somebody was sitting at trial. You get sworn in, and it's just like at trial. And depositions are taken in cases so that the testimony can be frozen for trial. Well, what does that mean? That means if you said something in a deposition, you better be consistent with it at trial, because it was under oath, right? Otherwise, you're going to be shown to be not credible or lying under oath, which is one of the worst things ever, right? You don't want to be a witness who lied under oath, and because you'll look terrible, and then no one will ever believe anything you say. And trust me, it's very easy to catch people and get them caught up in things. And that's what we're going to look at, how to do that in these specific witnesses in these depositions. So we start off with Jalen Curry. The first thing I wanted to note was it talks about him going to law school, but I think that's probably a clerical error. I don't think he went to law school, but we'll approach that as we get there. But Jalen Curry is the detective. He's the #1 witness for the prosecution. Most criminal cases, almost all of them, your best witness is going to be the police officer, the detective who did all the investigation. You might have an expert witness is a close second or maybe a first, but you're essentially hanging your entire case on this detective. So it's critically important on the prosecution side to build this guy up or gal, depending on who your witness is, build that person up, and then it's critical on the defense side to completely annihilate and destroy this witness. And there's a lot of ways to do that, in my opinion. But I'm a little jaded because I've cross-examined a lot of cops, and it seems pretty easy for me to show them all of the mistakes that they made. But let's start off with, even in the first line, my name is Jalen Curry. I'm 27 years old. Stop. Is that for the defense or is that for the prosecution?
Both.
Does that fact tend in favor of the prosecution or the defense? Think about it.
For the prosecution, we could play that he's young, he's inexperienced.
Which would be bad, right?
Or wait, that'd be the defense. I'm really tired. I apologize.
I think you're going the right direction. So yes, I think that is a huge factor in favor of the defense. This guy is very young, just out of school, just out of the academy, has not handled many homicides. And this is obviously a huge case for this small town. Next sentence, he attended Truman State University, received a BA degree in criminal justice. Prosecution or defense?
Prosecution.
Yep, favors prosecution because he has a degree. You're trying to build this person up, and say that they're not just a high school grad. They have the education, and it was in this field of study. Immediately applied for and was accepted into the police academy in Pinewood, Missouri. I'm from Pinewood, born and raised, and wanted to come back and raise a family. Prosecution or defense?
Prosecution.
Absolutely. He's showing he's a hometown person. He's come back. He or she, and I'm going to use these interchangeably because we don't know if Detective Jalen Curry is a female or male, or the gender. So we're going to just kind of go with that. Came back to home to raise a family, so people in this county are going to love this person. So I think that favors prosecution. See, in this where law school, it doesn't say that this person went to law school or what school. So I think they're saying after graduating undergraduate, but we'll have to clarify that. Said he's made some larger busts. I've made detective at just 25 years old. First year in narcotics and moved over to homicide in November 2019. All of that seems to favor the prosecution, given him experience. There's not a whole lot to attack there, except...
Would the defense be able to attack his lack of experience in homicide? Because he's been in there since November 2019, so it hasn't even been a whole year.
Yes. Yeah.
Okay.
Yep. Good point. Yeah. So I was going to say it, and You attack the age, you attack the experience of how long he's been doing this overall and how long he's been in homicide. The next sentence is interesting. Investigated 9 homicides with 5 resulting in convictions. Do we think that is relevant? Whether his homicides that he investigated resulted in convictions, is that relevant?
No.
Yes.
I can see an argument on both sides. I could see the argument that it is relevant because it's part of his experience, but I could see the argument that it's not relevant because we don't know if a jury convicted someone based upon his testimony. They might have convicted the person because the person was guilty and it was easy to tell from all the other witnesses that testified in the trial. So that would be the arguments that I would make on both sides. The other 4 remain unsolved. That's something you can point out from the defense. Okay, so almost half of these you haven't even solved, right? They haven't gone to a trial. You haven't arrested anyone. They're just completely unsolved. So, just barely over half you've arrested someone. The other ones you haven't even solved them.
But how would that be relevant to like this case specifically?
Because
Because it's like
go ahead.
it's like because those 9 cases are all like independent events with
Right.
like they're not interrelated, so like there's no relation between them.
The prosecution would say this is related to his experience, and so the jury gets to hear about his experience in order to build up his credibility. And then I think the defense would make the exact argument you're making, is that none of these matter, it has nothing to do with this case. We're here to talk about what he found in this case. I think at the end of the day, they're probably going to let it in, but I think it's an argument worth making. So this whole Southfield County being the Angela Lansbury effect, high number of mystery writers per capita. I don't know if any of that is relevant. Doesn't seem to be relevant to me. I don't see why you would want to put it in there for the prosecution. Doesn't really do anything to help build his credibility. And I don't know what it does for the defense either, really. So the next sentence, he talks about his training. He spent 3 weeks in training with the Missouri Highway Patrol, learning about forensic evidence such as collecting DNA evidence, analyzing fingerprints, and that kind of thing. So how would we approach that from the defense side? Anyone?
I would ask for like specifics on how he was trained and what he means by that kind of thing. Like, what is he specifically referring to?
Okay, and so you're on to something, but I want to make sure that we remember our cross-examination rules. And on the defense, you're cross-examining this witness, and so you don't ever want to ask a question that you don't know the answer to. So do you know the answer to that question?
No, because he's made an ambiguous statement.
Right. What about, did this case involve DNA evidence? Anyone? No, the answer is no. Did this case involve analyzing fingerprints? No. I mean, the way I would attack this on cross-examination is, yeah, you had all this training on, you were just talking about all this training on DNA evidence, right? In direct, yeah. And this case, you didn't do any collection of DNA evidence, did you? No. You didn't analyze DNA evidence, did you? No. And you didn't analyze any fingerprints in this case, did you? No. Okay. And then you just move on. And the point is, all of this training that they're trying to build him up with means nothing in this case. On the prosecution side of it, you say, well, it's just part of his training and he has experience. Same thing with the next sentence. It's really same deal. I could see the last sentence of the paragraph being helpful for the prosecution because this case does deal with a lot of interviewing witnesses, victims and suspects, note-taking, general observation skills. The one thing to be careful with here, though, is a witness cannot testify about the credibility of another witness. So he can't say, I didn't believe that person because they seemed like a liar to me, or anything like that. So all these skills, investigation skills, this could be used against the witness later when you say, well, you blew this one and you didn't, what investigation skill did you use to come up with that conclusion? Because honestly, there's not a whole lot of investigation skills going on in this case, I don't think. All right, let's go to the next page. He was on duty the evening of June 27 when he received a call from the captain about a suspected homicide. Everyone in Pinewood knows Gray. What about that statement? Everyone in Pinewood knows Gray. Can he testify about that?
That's a generalization, so no.
Yeah, I don't think he can say that. It's an opinion about who knows Gray. He can talk about what he observed and what he did. He can't talk about his opinions. I mean, if you put my opinion is in front of that and it makes sense, then it's an opinion. He's the wealthiest people, he is or was one of the wealthiest people in the country. Same thing with that. We knew he had houses all over the world, a lot more exotic than Pinewood. He became a local hero. All of this stuff, I think, is opinion. And he's a fact witness. Or at least he can't give an opinion on that. We'll find, I think he might be able to give an opinion on some other things. He arrives at the residence at 10:15 that evening. He receives a call on his cell phone from the governor. She asks about the investigation, and he tells her, I've not even gotten to the crime scene yet. Does that conversation come in to evidence?
It could, because it's recorded.
I think it could.
I can
I
see.
think it,
Oh, go ahead.
so, I was going to say I think it could because I think the defense could argue that there was a lot of pressure to find a suspect and pin it on that suspect fast.
I think so. What you're looking at with this is whether it's a hearsay statement, and I think so far it's not a hearsay statement to say that he received a phone call. Once we start getting into what the person said, then I think it could be hearsay. But I think the fact that the governor called him on his cell is a fact that he observed. And I think it's important. What does that go for? The defense or the prosecution? That the governor's calling him on the way there.
The defense.
Yeah, it definitely goes to the defense because it shows that they're trying to already, before they've even gotten to the crime scene, this governor is trying to rush the investigation. I think the defense, probably the entire theme of the defense is probably going to be that this investigation was rushed and there was no careful consideration. There wasn't really ever an honest investigation performed here.
So when Dean talks about a theme, and I'm going to bring this up because I think all of our lawyers that are on the defense are new. It's like having a story and you're telling a story from the beginning to the end. And so the story he wants you to tell is that this was a rushed job. So you're going to bring it up in the opening. You're going to portray that throughout the whole thing. And then in your closing, you're going to hit it again.
Exactly. And so let's just take that, for instance, a rushing. And there's a lot of attorneys that do it, and I never do, and I don't want you guys to do it. I think what you should do is have a theme, but don't say this case is about, well, that's just, I don't know, it just sounds dumb. I think the way to do it is in a more subtle manner, to talk about how they were, they were in such a hurry to get somebody, the governor even called, and you just all through opening statement. And then that'll go through your cross-examinations. And then in closing, you'll tie that all up because you'll say, or the person who's doing the closing will say, we told you in opening this, that they were rushing, and now we don't want you to rush. You'll come up with something, but you can't rush because this person's life is at stake, right? He could be convicted of murder, and you can't. This whole thing was a rush and a mistake. When you rush, something like that, you come up with something, but you keep it all tied into what you started out with in opening statement.
When you're talking about the rush, could you also bring up the fact that this kid is young, and when you're young like this, you're impressionable and you tend to do what the authorities or your people above you want more so than, like a 20 or 30-year veteran?
Yeah, I watched a guy give a closing. I gave my closing, then he gave his closing after me. But he said youth is wasted on the young. I don't know if you ever heard that saying, but I thought it was the most terrible thing to ever say in a closing. But the jury was a bunch of old people and they loved it. So something like that. The theme of, look, this he's a young guy. He doesn't quite know what he's doing yet. He's got pressure from the governor already. Before he even gets to the scene, he's got pressure that he's got to come up with something. So this is all being forced. It's all forced, and it's bad. It's dirty. It's quick. And you don't want to give a quick, dirty verdict. That's not how justice system works, right? Something to that effect. But you guys will come up with something great, I'm sure.
I have a quick question.
Yep.
So my computer accidentally cut off. When you guys were saying that we need to, as defense, we need to give rush, we say it was rushed.
So that's just part of the theme. You come up with a theme. I think rushing it in this is a good theme in this case, and you'll tie that in from opening all the way through closing.
Okay, that makes sense. Sorry, my computer just cut off.
No, you're okay. You're okay, and you can watch the video too. And we kind of went into depth on it. All right, so we're going on to the next part where what she says, right? She says, you need an arrest in this one and fast. So there you go. It goes right to the theme on the defense. A lot of people are watching. If you need any help or resources, you tell your captain to call me immediately. So I think we talked about this in the hearsay section, saying this probably is going to come in because it's an admission from a party The state is a party. This is the mayor, or the governor, I'm sorry. The governor is an actor of the state. So it's likely going to come in as an admission. What we didn't talk about, and I'd like to know, from the prosecution side, what are you going to do with this? How are you going to explain this when the defense keeps saying you are rushing? Even the governor said, get it fast. You need an arrest. What's your answer to this?
The family of the victim deserved answers and they deserved justice, and we wanted to provide them with swift justice. There was a large amount of evidence proving he was guilty. We weren't going to delay that.
I like everything you said, but I would stay away from the word swift or anything like that. I would say we wanted to obtain justice. That's what the state does. We had a murder on our hands. It was a murder of a very a highly public figure, and we wanted to make sure we got this right. So it's going to be, and this happens all the time in cases, it's going to be quality versus quantity, or quickness versus the quality of what's going on. And that's going to be the battle. And then here's the next sentence, you know, that the pressure's on this detective. I think that's very much, and this whole paragraph is really in favor of the defense. Because they are, you know, this is all how they're rushing everything. Governor's pushing him to get an arrest.
So would the feelings of the police officer, like if they felt like pressured, would that be considered a factor or an opinion in the court?
Well, I think when we go back to our hearsay rules, I think one of the things that we said was you can testify as to how you felt, right? So that's not a hearsay issue. It's not giving an opinion per se, because you're saying how you felt.
So you can ask if they felt pressured by the governor, like specifically, like.
I think the best way to ask it is, you were pressured by the governor, correct?
Yeah.
And, you know, if they say no, then you can say, well, you know, the deposition, you're sworn in and you said there's nothing like the pressure of having a governor demand an arrest before an investigation was ever begun. Isn't that what you said? Yes. And then that's the way you would do it.
Okay.
All right. So I think that whole paragraph is really for the defense. But I think we have our answer from the prosecution side. So the next paragraph, looking at dozen uniformed officers at the scene, parked the vehicle, and from the prosecution side, you're going to want to give all of this to the jury to give them an idea, a picture of what was going on. I think he can testify about all this stuff. What about at the end of that paragraph, a briefing from the first uniformed officer to arrive on the scene? She told him that there had been some sort of dinner party with a 1950s theme. Do you think that comes into evidence, or is that hearsay?
I don't think it would go into evidence.
Why not?
It's just really not that relevant that it was a 1930s party.
It's relevant enough, probably.
I don't know how they tie into the murder.
I think it's relevant. What about hearsay?
I would say it's not, because she is not stating it as a fact. She is stating it as like what she believes. Or wait.
So you're on it. The legal argument would be that it's not really for the truth of the matter asserted, right? So it's not really hearsay. It's a statement. It's an out of court statement, but it doesn't meet the definition because it's not necessarily for the truth of the matter asserted. It's just giving the officer a background information. All right, next paragraph. So part of this is tough because, you know, it says, I learned that the body of Gray had been located in the conservatory just before 9 that evening. Well, where did you learn that information from? Body had been left there, had not been moved before my arrival. Started my investigation by examining the body. Large pool of blood, no sense of there's no sign of tension. This is all stuff that they could get into. This is stuff he observed. This is all for the prosecution. But now, as we get down towards the bottom of that paragraph, I think that's where we're really going to get into the issue. So he talked about this training he had on cause of death, right? But I think the defense would attack that by saying, you know, you've never gone to medical school. You don't understand everything that's in the head. You weren't able to do an actual physical examination like a physician would do, right? You would defer to the coroner. Now, I think that the coroner probably comes up with the same opinion, but I don't think, can't remember. We don't have a coroner as a witness, do we? No, we don't have the coroner as a witness. So they're going to try to get in cause of death through the cop. So I would object on the defense side, say he's not qualified to give an opinion on cause of death. The counter argument to that from the prosecution would be he has the training on cause of death that he received in the police academy. And if it comes in, I think it's something you would definitely attack on the defense in closing, that this guy had absolutely no medical training, and to allow him to sit there and talk about the cause of death is insane. And to believe it would be nuts, because there's not been one single MD, DO, any kind of doctor, much less a pathologist, that they put on the stand to tell you what the actual cause of death was. They put on some 27-year-old kid who talked about it in a police academy class. That's what they put on. So how do you counter that argument on the prosecution?
You could counter it by, I guess, saying that, I mean, he's a detective, so he must have some background information. And I'm pretty sure they'd have to have a coroner, even if they don't have one as a witness, right? I guess. I don't know.
Well, I think you counter it by saying, look, he has enough training to know if this guy's been stabbed or shot or hit with a blunt object, okay? He didn't have any puncture holes in him. Nobody's saying he was shot, or nobody said anything else but blunt force trauma. So the defense didn't put up one single witness to tell you that this was something other than blunt force trauma. They didn't put up a doctor. They didn't put up their own police officer who went through their own police academy to say that it wasn't blunt force trauma. If you look at the facts of this case, that's the only thing that possibly could have caused the death, right? There's no holes in him. What else could it have been?
I mean, we Do we know his medical history? I mean, blunt force trauma doesn't necessarily have to be caused by a person. He could have fallen, he could have ingested something he was allergic to, been poisoned. So, I mean, there's methods that he could have died that would have caused blood loss and bruise other than blunt force trauma.
There's a million possibilities, right? And that's what the defense would argue. The prosecution, I'm echoing here. The prosecution, you would argue, there's only really one probable cause of death. There's really only one thing that most likely happened.
I
And
think it probably was an object because I believe it said something about multiple bruises.
yeah, I think there's enough evidence. There's blood loss, there's blood pooling, there's massive bleeding. You know, I think there's enough there for a jury to conclude it was blunt force trauma. Now, again, the defense argue, well, we don't know what caused that. That's fine. But the officer here is just saying it was blunt force trauma. All right. So the next paragraph, he mentions again an additional call from the governor's chief of staff asking for updates. And now also from the FBI field director. I was under a lot of pressure to get a Caller and fast. Ultimately, I arrested Parker Crimson, one of the party guests. I know it's cliche, but Crimson had the motive, means, and opportunity. I'm convinced Crimson is guilty based on several factors. Can he give the opinion that he believes Crimson is guilty?
Yes.
No, I don't think so. I don't think so.
Is he
I
not
think his
considered an
opinion's very
expert?
valuable.
Well, I think the prosecution may attempt to make him an expert. And you would say he had this training, he's been working in homicide. But I don't recall him having, you know, he had one week. If we go back to the front page at the bottom, he says, I spent an additional week training in forensic pathology, learning how to detect causes of death. So it's possible, you know, he's gonna, based upon this, they're gonna try to make him into an expert, I think, his training. But man, it's really thin. It's really thin training, I think. And I think you would argue on the defense that he's not qualified to give an opinion about an ultimate issue as to whether or not Crimson is guilty. He can talk about what he saw, what he heard, things like that. He can talk about his investigation, but he can't talk about his opinion that Crimson is guilty.
Why didn't they hire someone older?
Well, this is just the facts that you're given.
Oh.
So I think you also use this again to say, again, he's saying that he had pressure to get an arrest. And you could do that on the defense side by saying something like, you know, there was so much pressure under you to get an arrest as quickly as possible. You even mentioned it twice in your deposition, that two different people were pressuring the FBI field director, the governor's chief of staff, and the actual governor herself, right? I think that's how you would attack that. And then the same answers on the prosecution as we came up with before. Look, this was a high-profile case. We want to make sure we got justice done in an appropriate fashion. And so that's why there were a lot of different people involved in it. So last paragraph, Motive, this is where I began my investigation. Presume someone's in the house, must be the murderer. And I think it's important for the prosecution to go through all of this. No evidence of forced entry. I think he can testify about that. Security camera video they obtained from the residence next door showed 6 party guests and the paid staff arriving at the house, nobody else. Talk about the interviews that he did to support his opinions if he's going to be an expert. And I think he can. I think that's all for the prosecution. I think he can get into that stuff. Next paragraph, he talks about he learns that they're all involved in Gray's businesses. And I think he can get into that as well. I think that's all of the motives of the other people who are at the party are going to be fodder for the defense, right? You're going to try to be saying that all of these other people had motives and one of them could have done it. At the same time, on the prosecution, I think the way to take care of that is to bring it out in direct. So the sting is not there on cross-examination. You bring out that he investigated, he understood there were other people with motives. But at the end of the day, the evidence led to Crimson. Right, so next paragraph, this is all background information. The prosecution would have him testify about, who were the guests there, what was their involvement with Gray. Can he say no one had a greater motive than Crimson? So I think we have the same argument again. Can he give the opinion? That's clearly an opinion. So does he have training in determining who has a greater motive?
Could he say all evidence points to Crimson?
Yeah, I think he could say the evidence led to Crimson, or this evidence pointed in that direction. But if he says, I don't think he can say no one had a greater motive than Crimson, because I don't think he has any training at motive school. I don't recall that. Right? I mean, I don't see how he could say that.
It's hard to argue emotions because they all had a motive, so they could have felt like the same anger with like being thrown under the bus by like his company.
Right, and I think
it's just really hard.
That's why I think in the prosecution you're going to take care of that by bringing it out through the detective about everyone who had different motives, and you're gonna attack that right in the beginning, right in opening statement. You're gonna attack. You're gonna say everyone. There was a lot of motives here. You're gonna hear evidence of a lot of different people, but at the end of the day, when you follow the evidence, we're gonna ask you to find Crimson Parker guilty. And it's very similar. I had a and then it's going to make the defense look stupid when they get up and they say, well, this person had motives, that person had motive, blah blah blah. And you're gonna be like, well, didn't you hear me in my opening statement? I said these other people had motives, but who cares? We're talking about the evidence and what happened, that night, and where the evidence leads you. And it doesn't lead to all those other people with motives. It leads to Crimson Parker. Is that his name? Am I saying the name right? I think Parker Crimson. Parker Crimson, sorry. So, yeah, I had a case one time. My people were very clearly trespassing. And the first thing I said it in voir dire, not even opening statement. I said, my people were trespassing. And I spent about 2 hours. If the crowd had tomatoes, they would have thrown them at me for sure. They hated me. But by the end of the case, they were sick and tired of hearing about it. And that's what you want to do on the prosecution in this case. You want them sick and tired of hearing the same old, everybody else had these motives. So that's what you do in opening statement. That's what you do in your direct examinations. You bring out all the things that they were going to bring out on cross, so that when they bring it out on cross, nobody gives a crap anymore, right? Because it's already been said. We've all heard that. So what else is new? Okay, so we have this stuff about chartreuse, creating financial model. I think that comes in. All of these different motives, I think, are going to come in. And so I think at the end of the day, those are all in favor of the defense, but the prosecution wants to bring that stuff out early because you want to attack the weaknesses in your case. So I think at the day, this is actually all in favor of the defense because these other folks have motives. Now, what about this Gray's quote to the media? I think we covered this in hearsay a little bit with respect to this movie release. When he says, "But I always win. I'm not having a movie where 2 out of 3 times I end up a loser." Does that come in? Or is that
I think so.
It's hearsay, right? It's out of court statement.
Yeah.
Although I think the argument would be you're not proving the truth of the matter asserted. Not whether or not the movie would, whether it was true or not, that he always wins. I mean, who cares if he always wins? You're using it to prove a motive against the Hollywood producer. What's her name? Quinn. So then you say you're using that to show there's a motive there. Doesn't matter if it's true or not. What matters is it pissed off Quinn, right? That's what matters. That's what you're putting it into evidence to prove. So next paragraph. Again, Crimson's motive took the cake, right? I don't think he can say that. Again, he's given his opinion about whether his motive is more than other motives. And so the other part of this paragraph here, he's talking about Crimson and the deal he had with Gray. I think it's kind of wrong, isn't it? Didn't Crimson get something out of the deal? It's very unclear to me. I don't think he got nothing, but because then he gave some portion of it to one of the other witnesses. But I think you can say all this. And now you're going to get into the emails. And so when you're on the prosecution side, you'll want these emails as an exhibit, and you'll approach and say, "May I approach?" And you'll hand them the emails and say, "Did you rely on these emails in your investigation?" Yes. And provide the foundation for that to get in your emails. All right, so the next paragraph So that whole paragraph, by the way, is for the prosecution, I think. Everything from that on down, yeah, I think that's all for the prosecution. And then on the next paragraph, they talk about the evidence was thin. Captain telling the detective that the evidence is thin. Do you think that comes in evidence?
Yes, because it's talking about the quality of the evidence given.
I think it comes. Yeah, I think it comes in. I think it comes in probably because it's an admission. Again, there's no reason for it to be out. If it is hearsay, it's an admission by the state that the evidence is thin. And honestly, you know, I would probably use that in my opening statement that they even knew the evidence was thin. They admit the evidence was thin. So same thing with this. Again, the pressure and the rushing. Captain tells the detective she's getting pressure almost hourly from politicians wanting updates. She would write the warrant application herself. Amazingly, the judge signed it. You know, I would ask him, well, that you were surprised, weren't you, that the judge even signed it? You had such thin evidence. I think it goes to how they're feeling, and I think that comes in. That's an exception to hearsay. So I think all of that really goes for the defense. I can't think of anything there that goes for the prosecution. But your next paragraph is where you really get in for the prosecution, because they go and they execute on this warrant. And I think what Crimson tells the police is okay, because even though it's hearsay, it's an admission. So it comes into evidence. What about the detective testifying that Crimson appeared genuinely surprised by her appearance? I think the detective can testify to that.
I think it could go into evidence. I don't know about anything else.
What do you guys think? Anybody else?
I mean, it is a direct observation they're making, and I believe as part of like police training, you learn how to like. Didn't he have training in questioning witnesses?
Yeah, and that's the argument on the prosecution side, is that he had training in determining and interviewing witnesses, so he can make that determination. The argument on the defense side is that's just an assumption. You know, just his facial expression could have meant a number of different things. And while he can testify as to what his actual facial expression was, like were his lips upturned, downturned, his eyes, what he saw, what he can't do is testify about what his opinion is on what that meant. So, next paragraph. What about the first word next paragraph? Jackpot. What would you guys do with that from the prosecution and for the defense? Anyone? I think it shows from the defense, I would argue, it shows that, look, this guy's rushing to get an arrest, and they finally find some reason to arrest this person, this innocent person. That's why he shows his bias right here. All he wants is to try and arrest Crimson. He doesn't care, whether he's actually guilty or not. From the other side, I think you would argue, well, he's saying jackpot here because he actually found something that links Crimson to the murder. And this is a high profile case. You want to make sure they get it right. And now they are getting it right. Now they found some evidence. And so they're excited to try and push the case forward towards justice, to bring justice to the family of Mr. Gray. So they talk about they found this layout. And does the layout itself come into evidence? Or is it hearsay? The residence layout.
I believe it would come into evidence because it was seized under a warrant through proper channels.
Okay, so even though it's seized under warrant through proper channels, it still could be hearsay and could be excluded if it were. But I think a layout is you're using it to show motive, and that Crimson had the layout of and a plan, a blueprint per se, of the residence before he went there. And so that's what you're using it for more so than anything. You're trying to go to the state of mind, using it to prove the state of mind of the defendant. That they had this in their head. They knew the secret passage to the study. And that's all you're trying to prove. What about the note? Let's see. I'm sorry, the receipt. I think we talked about that last time. The receipt would be a business record, so it would come into evidence. And I think that's probably right here is, in my opinion, the best evidence for the prosecution. The fact that he has a receipt for this gun means one of two things. He's the murderer, or someone else is trying to frame him. Right? Am I missing anything? I'm opening it up here. I mean, are there any other ways that he could have this receipt in his house?
I think he's probably getting framed.
And that's what I'm saying. And I think that favors the prosecution by quite a bit, right? Because I think at the end of the day, in your closing, you could argue that, look, they talked about all these other motives, these other people, these motives, but they never really developed how one of these other persons that they talked about actually went about and did it. Except for, I think the two, Butler and Chartreuse, I think that's going to be the theory you're going to have from the defense side. It kind of corners you into having that theory. Because on the defense side, you'd love to argue that, well, they just didn't prove it. But I think this receipt here kind of corners you into, and I think as a prosecution, you want to corner the defense into only having two arguments. And that is that really only one argument. The defense has one argument, that somebody else did it and they framed Crimson for the murder, right? And I think as the prosecution, so I think this is so critical for the prosecution, because I think you can say there's only one other option. Either Crimson Parker did, or Parker Crimson, I keep getting it wrong. Parker Crimson did this. He's guilty. Or somebody else did this and framed him. So think about that. Have you heard any real evidence on how someone planted this receipt into his home? And since you've heard no evidence on that whatsoever, the only thing you can conclude is that there's only one reason why that receipt is in his home. And that reason is because he was trying to set up and frame these other people. He was trying to make them look guilty when he was the one who was going to murder them. He knew he was going to murder them that night.
And do we know that he bought the exact gun? Like, we have like registration that matches.
It says in the last sentence there, this was the same gun that was discreetly delivered to Professor Chartreuse's home several weeks before the dinner party.
Let's verify that it was the exact same gun.
Yeah, so you are to assume that it was the gun that Professor Chartreuse received in the mail, or not in the mail, the butler delivered it, right? Is this gun. And so how in the world would he get this? So I really think it comes down to, the defense is going to have to prove that Chartreuse and the butler did it in order to prove that Crimson did not do it.
But there weren't any bullet wounds, were they?
Any what?
Bullet wounds.
No. The point of the whole point of the gun would be, why is he sending this gun off to Chartreuse unless he's planning on murdering Gray, and he wants Chartreuse to look as if he had motive and opportunity and wanted to kill Gray.
Oh, okay.
But there was no gun as part of the murder, so how would that even, how is the gun relevant to the specific instance that he was murdered?
I think that's the argument you'd make on the defense side, is that there's no reason to believe he was setting anyone up, because what's he going to do? He's going to send a gun out to someone, and then he's not going to use a gun in the murder. So what does that do? But alternatively, what is the other reason why he would have this receipt? And why is he sending a gun to Chartreuse? So, yeah, I think it's kind of muddied up a little bit there, but I think it's good evidence, only in that it kind of corners the defense into having to kind of prove that somebody else did it, which normally the defense is just saying, our guy didn't do it and they didn't prove it. But now they're kind of cornered into actually proving a case that somebody else did it. The last paragraph, talk about opportunity, blunt force trauma. They go back to, he had 1 week of training on causation of death. So, all the same arguments there. He's not a doctor, et cetera, et cetera. The whole fireplaces, the fireplace pokers, just because one is missing, that doesn't mean anything. So I think that's something to attack on. I mean, it's something you put in as a prosecution and something you attack on the defense. And at the end of that paragraph, that poker seems to match the type of cast iron tools. I think you definitely attack that on defense. Seems to, but you don't know for sure. And
Are we gonna be able to access this like file with it all edited?
Yes, I will send you a link to it once we're done with it tonight.
Okay. Thank you. Sorry for interrupting.
No, you're fine.
And then, unfortunately, they did not find any evidence such as traces of blood. So again, it's showing that this detective is biased because he wants to find evidence that Crimson did it as opposed to just finding the actual killer. Because he's saying, unfortunately. So there's a lot there, both for the prosecution and for the defense. Didn't find blood, but they did find that it had been recently cleaned. What about this next paragraph? Chartreuse says Crimson's guard was outside the door to the conservatory after power was restored to the home. Crimson exited from the study at the time power was restored. So it's hearsay, but if he's determined to be an expert, then experts can rely on hearsay. So those are your arguments there. The next paragraph, again, goes into the motive, and he goes into how he thinks all this went down. So again, I think, the argument's going to be there. Can he give an opinion about what happened that night? I don't think he can. But that's the argument. I would object to him giving that opinion. On the other side of it, they would say, well, he has the experience. He does these investigations all the time, so he can give an opinion on what happened. And so I think that kind of covers it all for this witness. I was hoping to do more than one witness tonight, but I think that kind of did it. So yeah, so all of that last paragraph is his opinion on what happened. And so as the prosecution, you're going to want to get that into evidence because, this is your star witness, and you're going to say he has the experience and the training necessary to give this kind of an opinion. On the defense, you're going to say, yeah, does not have that kind of training. He can't give an opinion about what actually happened that night.
Would it be smart to, if there was, if the prosecution was trying to get in, something that, barely even proves that Crimson killed him, would you allow them to, take it into evidence so you could counteract that?
Yeah, that's a good point. There's a lot of times where you don't necessarily want to object because you have the answer for it, and it's going to make them look terrible for putting it on into evidence. And so you kind of lay the trap by not objecting and allowing it into evidence and then attacking it. For our purposes, I think the majority of the time, 99% of the time, I want everyone to object if they have the legal support to object.
Okay.
If you have a reason to object, go ahead and object and make your statement and make your argument, because the judges for these mock trials, they're going to be looking to make sure that you understand and know the rules. And when you object, then that shows that you know the rules. Now, that doesn't mean I want you to stand up and object at every single question. That would just not, that would not work. And people will not like you for that. So don't want to do that.
So, Brett, in answer to your question, there's never a mistrial. So, what the trial judge is the one who determines who wins. So the judge is the one who says the prosecution or defense wins. The judge, the other people in the room, the jury, are giving points for performance of witnesses and lawyers. So, like Dean said, the judge is looking to see that the lawyers know the rules and know how to object and know how to stand up to the objections, because you'll have, you'll throw in an objection and then the judge will allow the other side to react to it. And so the mock trial is not just about who argues the case better. It's also who's learned the rules of trial as well. Does that make sense?
Yeah, but so are you familiar with the movie like 12 Angry Men?
Oh, yes.
Mm-hmm.
So if the ruling is like, say the ruling is
Yes.
that where it's like there's not enough evidence for a probable cause, which side would that favor?
So you're saying if the judge says that there's not enough evidence to prove that the
There's
defendant,
not enough to like prove innocence or guilt. Like there's not enough to convict, and there's not enough to completely throw the case out.
so that ends up just being a call that the judge makes.
Yeah, so I think what you're trying to get at is against the weight of the evidence. And so when a jury comes back with a verdict, you would have a post-trial motion to the judge to say, you know what, that verdict was against the weight of the evidence. You know, all of the evidence pointed to A and the jury found B. And so that's a motion you would file. And I will tell you that in practicality, you will absolutely never win that motion because the judges always defer to the jury.
Okay.
So guys, I just put a link in the chat to all the stuff that I just did. Could somebody open that for me and make sure that you can see all my notes?
I will right now.
Fabulous. And I think, Dean, the reason we only got through one tonight was because this is such a long deposition. I think the other ones are shorter.
Okay, good.
Yeah, I think, like you said, since there's our witness, it's really long, but I don't remember the other ones being this long.
I was able to see your notes on my iPhone.
Yes. Okay, good. So I will post that link in the classroom. But what I was finding is that as the further I got into the document, the longer it was taking my computer to load it. And I think it's because it's a 65-page document and it's trying to run it through an extension. So I will leave this up, but then when we do the other depositions, I'm going to scan in each one individually so they're each their own link, because I'm afraid that it's going to lose it.
And so just to take you back from the trees back to the forest, you know, from the prosecution side, you're wanting to show this guy is, he's competent. He's coming up the ranks very quickly. He knows what he's doing. He got the right person. They found actual evidence once they did a search that links Crimson to the murder. And then on the defense side, you want to say that, look, he's young, he doesn't know what he's doing, doesn't have a lot of experience, and it's rushed. He's getting pressure from his bosses. He's trying to, and he's biased, right? Because he's constantly saying how it's fortunate if he finds evidence against Crimson and unfortunate if he finds no evidence against Crimson. He hates Crimson. We don't know why, but he does. Well, we know why. He wants to get an arrest very quickly, and this seems to be the most convenient person for him to get an arrest from. So that's kind of the two competing theories, generally speaking. Anybody have any other thoughts or questions?
So you said like how he wanted to arrest Crimson because of he hated him, but doesn't have a motive. Like I don't know. You said like he wanted to arrest him because he hated him, right?
I think he wanted to arrest him because he wanted to get a quick arrest. I think I probably misspoke there. I think he just wanted to arrest him and find evidence on Crimson because he's the most convenient subject, convenient suspect for him.
Okay, that makes sense. Sorry, I was just confused for like a second.
Yeah, sorry about that. Yeah, I don't
Fine.
think there's any evidence that he hated Crimson, but I think he wanted to get an arrest very quickly, and Crimson was the most convenient person to do that for him.
So guys, I'm sharing the Google Classroom just so you can see how I've got it organized. Go to the classwork and I've got deposition analysis. So there's the one that we just did. And then I'll keep adding the ones that we do from here on out. The other thing is my YouTube channel. So if you go into the YouTube channel and subscribe, you'll get a notification anytime I post a new video so that you'll know when I post these meetings. But I also am posting links to them as well here. And then we will be getting what they call page notes. It's a judge, I think it's a retired judge who goes through the whole case and gives notes and comments. We should be getting that probably within the next couple weeks. And then the other thing you can look at just for kicks and giggles is at the very bottom, I gotta find it, where the ballots, that was the one ballot that we got last year. It was an electronic copy. So if you're interested in what the ballots look like, this is our actual feedback from the judges that we got, if you want to take a look at that. So the classroom's got a lot of stuff on there that will help you. So yeah,
Yeah.
I think that's all.
One thing I want to say, the page notes are so critical. There's a judge that goes through each sentence, almost like what we just did, and gives exactly what argument you would make for the prosecution, what argument you make for the defense, as far as that evidence coming into evidence or not. So don't worry about if you feel like I'm lost on all this evidence rules and all of that. You'll get these things called the page notes, which is just exactly the same packet, but it has a judge's notes in there telling you all the answers. It's like an answer key. So that's going to be very helpful if you feel lost on all these legal arguments.
It'll start to make more sense the further we get into this. Okay, well then I think that's it for tonight. I'm going to download this video and upload it to YouTube tomorrow when I get to work. And if you need anything between now and Monday, so we'll have another meeting on Monday, and we'll go through hopefully 2 other depositions, and at each of our meetings, we'll keep going through the depositions and talking about them until we get done. And then I think we'll break into breakout rooms so you guys can like work on putting your arguments together and creating your questions for direct and cross and your opening and closing and all that stuff. Do you guys need anything? Have any questions? I want to thank Dean for taking time out of his evening to meet with us. This is a complete volunteer role, so.
Wait, I'm not getting paid?
I'm not getting paid either, brother.
Thank you, Dean.
This is part of my contract. Payment comes when I say, guess what? We won. The look on everybody's faces last year was priceless.
Oh yeah, that was really cool. Everybody having fun. That's reward enough for me. To see you guys learn this stuff and enjoy academics. You know, so many people don't like thinking cognitively and critically, but I enjoy it.
All right. Well, you guys have a good night. Go enjoy your 6-day weekend or whatever